I am Opeyemi Bamidele. I represent FCT Central Senatorial District. Mr. President, I do move that the Senate do consider the report of the Committee on Judiciary, Human Rights and Legal Matters on the Federal Capital Territory Customary Court Act 2007 Amendment Bill 2021 SB 315. Mr. President, I so move.
This
report of the Senate Committee on Judiciary, Human Rights and Legal Matters on a bill for an act to amend the Federal Capital Territory Customary Court Act 2007 to alter the quorum of the court for the purpose of ensuring timely dispensation of justice, expand the jurisdiction of the court to include the trial of criminal matters and for related matters. The Federal Capital Territory Customary Court Act 2007 Amendment Bill was sponsored by distinguished Senator Opeyemi Bamidele, FCT Central Senatorial District, as a stakeholders bill. The bill was read for the first time on Thursday, 27 February 2020. At the plenary sitting on Thursday, 12 March 2020, the Senate debated on the general principles of the bill. After extensive debates, the bill was read the second time and referred to the Senate Committee on Judiciary, Human Rights and Legal Matters for further legislative action. Via order of referral dated Tuesday, 17 March 2020, to report back with its recommendations. Mr. President, because of time, I am moving to paragraph 4.0, legislative action. In furtherance of this assignment, the committee relied on the legislative framework earlier agreed upon as the way forward. In addition, the committee made wide consultation with relevant stakeholders in order to elicit their input on the proposed legislation and also considered views expressed by distinguished senators on the merits of the bill during debates on its general principles. Mr. President, distinguished colleagues, for the avoidance of doubt, I wish to state that preponderance of opinions expressed on the bill by stakeholders support its passage as an act of the National Assembly. The committee also scrutinized in detail all the views canvassed on the bill. Below are the highlights of the views expressed by stakeholders on the proposed legislation. It is apposite to state, Mr. President and distinguished colleagues, that stakeholders re-echoed their absolute support for the passage of the bill by stating that its introduction at this point in time is a welcome development as it is aimed at reducing the quorum of the Federal Capital Territory Customary Court for speedy trials, as well as expansion of the jurisdiction of the court to undertake criminal matters in order to ensure quick dispensation of justice and to reduce the workload on the magistrate court. The criminal jurisdiction being sought through this bill is appropriate and acceptable as all the judges of the court are legal practitioners who are competent to sit over criminal matters and as well knowledgeable in customary law. Stakeholders stated that the FCT Customary Court upon its establishment was charged with the responsibility to exercise jurisdiction over causes and matters within the territorial limits of the Federal Capital Territory, as set out in the schedule to the Act, with particular reference to Section 14.1 and 2 of the Act. Part 1 of the schedule vests civil jurisdiction in the customary court, while Part 2 vests minimal criminal jurisdiction on the court, which has made it impossible for judges of the court to sit on criminal matters. They submitted that the intent of the bill is revolutionary and a welcome improvement on the principal act. They stressed that the objective of the bill, apart from seeking to declog the dockets of magistrate courts in the FCT, is also to seek to expand the criminal jurisdiction of the court, which would expose judges of the court to the rudiments of criminal trials, which are highly essential upon elevation to Court of Appeal, where any matter can be assigned to a judge. Therefore, it is expedient that such necessary alterations are made on the principal act to ensure that the court is not limited in scope in the performance of its statutory duties. Mr. President, distinguished colleagues, I am moving to paragraph 5 on page 5, legislative summary. Mr. President, distinguished colleagues, in the course of the committee's deliberations on the bill, after the committee hearing, the inputs canvassed by stakeholders were considered and reflected in this report. Similarly, editorial corrections were also made to ensure that the bill conforms to normative legislative drafting styles. The summary of some of these modifications are stated below. Long title. The long title of the bill was redrafted because from the provisions of Part 2 of the schedule to the Extant Act, it is clear that the court has minimal criminal jurisdiction. Therefore, the purport of this bill is to expand the criminal jurisdiction of the customary courts since they are manned by legal practitioners and not to confer criminal jurisdiction afresh. Clause 5. Clause 5 of the bill amends Section 49 of the Principal Act. The usage of and or in the clause is disjunctive, as each court of the customary court has its own appellate jurisdiction as conferred by the Extant Act. Therefore, the word and has been deleted as shown on the attached table because it is redundant in this context. Clause 7 amends Section 65 of the Principal Act. This clause was introduced by the committee in view of the expanded criminal jurisdiction of the court. By the expansion, there should be a corresponding amendment to Section 65 to encompass the elements of the expanded criminal jurisdiction of the court. Accordingly, the existing provision was renumbered as subsection 1 and a new subsection 2 was introduced, as set out in the attached table to this report. Clause 8 of the bill was introduced by the committee. The clause amends Section 66 of the Principal Act, which deals with the interpretation section. Some terms in the interpretation section have been amended in line with the expanded criminal jurisdiction of the court. Our observations and findings. Mr. President, distinguished colleagues, flowing from the analysis of submissions made by the stakeholders on the bill and based on clause-by-clause consideration by the committee, we hereby make the following observations and findings. 1, that the introduction of the bill is laudable and commendable as its passage into law will go a long way in addressing most of the challenges in our justice delivery system. 2, that the bill in its entirety is revolutionary in the justice sector reform and will help generally in effective justice delivery through the proposed enhanced legal framework. 3, that the alteration of the customary court quorum from 3 to 1 will no doubt enhance quick dispensation of justice as unnecessary postponement of trials occasioned by absence of one of the 3 judges will no longer stall the proceedings of the court. 4, that the provision of the Principal Act in Section 3 provides that a judge who did not take part in the hearing of any cause of proceeding shall not take part in the judgment of the court. As such, the quorum of 1 judge per case will enable the court to achieve a high level of efficiency in fulfilling the requirement and determination of matters within reasonable period as provided in Section 36(1) and 4 of the 1999 Constitution of the Federal Republic of Nigeria as altered. 5, that the utilization of the existing customary court judges will help to fulfill the intendment of the bill without imposing additional financial burden on the government. This will in turn lead to quick dispensation of justice. 6, that this amendment will not only declog the docket of the magistrate courts, but will enhance the efficiency of the court in the resolution of the ever-increasing civil matters due to complexity of modern life. 7, that the FCT Customary Court currently are manned only by qualified legal practitioners with vast experience as encapsulated under Section 4 of the Principal Act. Yet, the court is not conferred with criminal justice jurisdiction while their counterparts in the states are vested with such criminal jurisdiction. 8, that this amendment will position the judges of the court for elevation in the judiciary. as their potentials and expertise in the area of law are reviewed, thereby forming a valid base for accessing their performances by appellate court. 9, that the amendment of the Customary Court Act shall have consequential effect of a deemed amendment to Section 494 of the Administration of Criminal Justice Act 2015 and Section 4 of the Federal Capital Territory High Court Act Cap 510, and 10, that it is trite that where there are 2 or more legislations on a subject matter, the latter legislation prevails. This is espoused in the Supreme Court case of Attorney General of Anambra State and others, and AG of the Federation and others, reported in 1993, FPELR, page 315-7. Our recommendation: the Senate Committee on Judiciary, Human Rights and Legal Matters, to which this bill was referred, having considered same, recommends as follows: that the Senate do pass the Federal Capital Territory Customary Court Act 2007 Amendment Bill 2021 as amended. Mr. President and distinguished colleagues, on behalf of members of the committee, I wish to express our gratitude for this opportunity to serve you and our colleagues and the people of the Federal Republic of Nigeria. Thank you so much, Mr. President. I so...
Bill 2021 and approved as follows: long title as recommended, clauses 1 to 7 as recommended, interpretation as recommended, short title as recommended, schedule as recommended, explanatory memorandum as recommended. Is this a true reflection of what transpired in the Committee of the Whole? Thank you. Leader of the Senate.
Mr. President, I rise a motion that this motion be read the third.
A bill for an act to amend the Federal Capital Territory Customary Court Act 2007 to alter the quorum of the court for the purpose of ensuring timely dispensation of justice, expand the jurisdiction of the court to include the trial of common criminal matters and for related matters, 2021, third reading taken, and the bill is passed. Congratulations, Leader of the Senate.
Mr. President.